All right, moving on to the next case to try and illustrate this idea of judicial restraint or judicial activism. You see, so far the court, particularly in Barron versus Baltimore, has taken a judicial restraint view. They refuse to expand the Constitution to this, the amendments of the Constitution onto the state's government because the document clearly intended it for it to only limit the national government. So in the slaughterhouse cases, it's 1872. The nation's been around almost for 100 years now. Here's the facts of the case. A Louisiana law of 1869 chartered a corporation, the Crescent City Livestock and Landing and Slaughterhouse Company, and granted to it a 25-year monopoly to maintain slaughterhouses, landings for cattle, and stockyards in an area which included the city of New Orleans. All competing facilities were required to close, but the corporation was required to permit independent butchers to slaughter cattle in its slaughterhouses at a charge fixed by statute. The butchers not included in the monopoly claimed that the law deprived them of their right to exercise their trade and challenged it under the 13th and 14th Amendments. The highest state court sustained the law, meaning they agreed with the law. So, you're on the Supreme Court. What would you do? So you have some butchers coming to you claiming that their constitutional amendments have been violated because they were not included in this monopoly, or as it were, the monopoly itself is unconstitutional. So what would you do? What would you do? Think about that for a second. Pause this thing and then come back to it. All right. This is an easy case. This is what the court says. This is an easy case. They say, the most cursory glance at these articles discloses a unity of purpose when taken in connection with the history of the times, which cannot fail to have an important bearing on any question of doubt concerning their true meaning. Nor can such doubts be safely and rationally solved without a reference to that history. Fortunately, that history is fresh within the memory of us all, and its leading features as they bear upon the matter before us are free from doubt. So what is that history? So the question you have to ask yourself, what are the 13th and 14th Amendments all about? And what the 13th and 14th Amendments are all about is the 13th Amendment prohibits slavery. The 14th Amendment gave citizenship rights to the former slave, the new freeman. They had nothing to do with this idea that there couldn't be monopolies or gave individuals a right to exercise their trade. So what these butchers who are not included in the monopoly are trying to make an argument that they should extend the meaning of the 13th and 14th Amendment to something that they were never intended to protect. This is judicial activism, and if the court agrees with that argument, they're committing this kind of judicial activist or accepting this judicial activist philosophy. The problem with that is once you open that door, where does it stop? Where does that judicial activism stop? And so the court says, no, this is an easy case. This is an easy case. They dealt with slavery and with the free man, creating the new free man. You don't have any right to this. Now, if you look at also what's going on, what was happening at the time, and this even makes it an easier case. So what butchers were doing at the time is they were taking and butchering a cow, a pig, or whatever. They were just taking its guts and dumping it in the river. So people downstream from the river were getting sick. So this was Louisiana's way to try and get some health and safety for their people. And this is particularly interesting in this age of the pandemic. You've got to do something to protect the health and safety of your citizens, and that's exactly what they were doing. This maybe wasn't the best way to do it, but it's a way they came up with, and it certainly didn't violate the Constitution. It's what the court said. And so again, another way you can say that what was happening here is the court was refusing to take the Constitution or its amendments out of context. Now, all that would change with the next case. So Lochner versus New York, 1905. Here are the facts of the case. A New York law prohibited the employment of bakery employees who were more than 10 hours a day or 60 hours a week. Lochner was convicted and fined for permitting an employee to work in his Utica, New York bakery for more than 60 hours in 1 week. So you're on the Supreme Court. What would you do? What would you do? Think about that for a second, and then you can pause it if you need to, and then go to the next screen. So here is the lead opinion of the court. So there are some concurring and there are some dissenting opinion of the court, but here's the majority opinion, the lead opinion. And this is what Justice Beckham says. It says the statute necessarily interferes with the right of contract between the employer and employees concerning the number of hours in which the latter may labor in the bakery of the employer. The general right to make a contract in relation to his business is part of the liberty of the individual protected by the 14th Amendment of the Federal Constitution. Under that provision, no state can deprive any person of life, liberty, or property without the due process of law. The right to purchase or to sell labor is part of the liberty protected by this amendment unless there are circumstances which exclude that right. There are, however, certain powers existing in the sovereignty of each state. So let me stop right there for a second. So do you see what happened? The court just became activist in Lochner versus New York. They just said in the previous case, in the slaughterhouse cases in 1872, that they would not take the Constitution out of context. And here, they're claiming that the liberty protected in the 14th Amendment's due process clause basically is the liberty to make contracts. That's not what it meant, and they knew it. What liberty meant in those days was liberty was the right to be free from jail for no reason. So the court became activists. They skewed what this right meant, and then they began to fill in what they felt it should mean. So they began to be judicial activists. And that's what was going on. Okay, then he goes on, Peckman goes on, and he begins to talk about this thing known as the police power. He says, there are, however, certain powers existing in the sovereign each state in the Union, somewhat vaguely termed police powers, and the exact description and limitation of which have not been attempted by the courts. Those powers, broadly stated, and without at present any attempt at a more specific limitation, relate to the safety, health, and morals and general welfare of the public. Both property and liberty are held on such reasonable conditions as may be imposed by the governing power of the state in the exercise of those powers, and with such conditions, and 14th Amendment was not designed to interfere. It must, of course, be conceded that there is a limit to the valid exercise of the police power of the state. So they're saying, look, the government has certain powers, even if they're not specifically granted by name, that are part of this overall police powers. So they're recognizing that the government has some right to legislate. And then he goes on and he says this. In every case that comes before this court, however, where legislation of this character is concerned and where the protection of the federal constitution is sought, the question necessarily arises, is this a fair, reasonable, and appropriate exercise of the police power of the state, or is it an unreasonable, unnecessary, and arbitrary interference with the right of the individual to his personal liberty? So what they're doing is they're saying, yes, there is an appropriate power of the state under this police power to pass legislation. But then they make this very vague, very subjective standard. They say, is it fair, is it reasonable, and is it appropriate exercise? So who's going to determine if it's fair, reasonable, appropriate? Well, the court is saying right now, it will. The reality is, whose job should that be? That should be the job of the legislature. And if we don't like it, then we approach our legislature, say we don't like it. If they don't do anything about it, we vote them out of office. That should be the remedy. But this is where the court begins to be activist. So that is what is going on right here. Now, not everybody agreed. So here's two dissenting opinions, or portions, a very small portion of them. Harlan said, whether or not this would be wise legislation is not the province of the court to inquire under our system of government. The courts are not concerned with the wisdom or policy of legislation. So you might find this offensive because you're thinking within yourself, well, they should be concerned with the wisdom or policy of legislation. That is the function of the legislative branch. Holmes says it differently. He says the case is decided upon an economic theory which a large part of the country does not entertain. If it were a question whether I agreed with that theory, I should desire to study it further and long before making up my mind. But I do not conceive that to be my duty, because I strongly believe that my agreement or disagreement has nothing to do with the right of the majority to embody their opinions in law. Boom! That's what it is. So he's coming from a judicial restraint. The legislature, they are the elected majority. They have the right to embody their opinions of the law. If they can get it passed, that's what it is. As long as it doesn't specifically violate a written portion of the Constitution not taken out of context. That's what his argument is. But nevertheless, the majority have the numbers, and so Lochner versus New York began this bent by the court of judicial activism. Let's skip that for a second. We may come back to it. Now, what happened in the meantime, so the Supreme Court went on with this stint of judicial activism for about 30 years. And then what happened was the Great Depression happened. And when the Great Depression happened in 1932, as you know, FDR was elected. And he was elected under this promise that he was going to do whatever it took. And if he was going to try something, if that didn't work, he was going to try something else. So he and the democratically controlled legislature passed legislation after legislation. And some of the court didn't agree with it. They didn't agree with everything that was going on. And they began to declare certain things unconstitutional based on this philosophy of Lochner versus New York. They thought it was unreasonable, unnecessary, not wise. And so what FDR did was he proposed packing the court. He said that the court was overworked and that the individuals on it were old, all the men were old, and he said for everybody that's on it that is 70 years old or older, I'd like the power to appoint an additional justice. So that would have brought the court from 9 to 16. And everybody knew what was going on here. Everybody knew that he was trying to manipulate the court. And so in this case of West Coast Hotel versus Parrish in 1937, a guy by the name of Justice Owens Roberts, he switched his vote. So in the past, he had been voiding a lot of the New Deal legislation because it was unreasonable, unwise, or unnecessary, and he switched his vote. And he began to accept what he deemed once unconstitutional is now constitutional. And then, now here are the facts of the case, and you've probably already read them as I've talked, so I'm not going to go over them. I want to go over some of the things that are said here. Okay, so the principle, so this is part of the opinion. The principle which must control our decision is not in doubt. So the court is giving its opinion. The constitutional provision provoked is the due process clause of the 14th Amendment governing the states, as the due process clause invoked in the Atkin case governed Congress. In each case, the violation alleged by those attacking the minimum wage for women is deprivation of freedom of contract. What is that freedom? What is this freedom? And here's the tell-all. The Constitution does not speak of freedom of contract. It speaks of liberty and prohibits that deprivation of liberty without the due process of law. So the court is admitting that it put its own values, its own opinions, what it thought was reasonable and just or wise or unwise. And what they admitted in this case of West Coast Hotel versus Parrish, they admitted that they were doing that. And the effect of this decision was to say, we will no longer Lochnerize. So what do I mean by Lochnerize? What did the court mean by Lochnerize? What they meant by that was they would no longer substitute their will, what they thought was wise or just or necessary or unnecessary, for that of the legislature. They said, if it goes with the Constitution, if it squares with the Constitution, we will just leave it alone. We will leave it alone, and it is Constitution. It is not our job to substitute our will for the will of the democratically elected legislature. We will no longer be a critocracy. All right, we'll pick up there with the next video.